Okay, all right, so here we are at the final segment of our sessions today. We have our distinguished panel of practitioners who are going to speak to us a bit about their background professionally, their experience with legal research, their tips, advice. They're chock full of good information for everyone in the room. So first we have Rob Dean. He is a 2010 graduate of the law school here. He's currently an associate at Gentry Locke in Roanoke. And his wife, Jennifer Grace Dean, she is an associate at Porch Law Firm in Salem, right? Right next door. Close to Roanoke. And we have Christopher Russell. He is the Commonwealth's attorney in Buena Vista and also an adjunct professor here at the law school. So we'd like to welcome them, and we'll open up a discussion by having them introduce themselves a little bit, tell a little bit about where they're from. And then we have some questions that we might throw back and forth a little bit. We'll, of course, have time for questions if there are questions from you guys, and they'll be happy to answer it. They are very willing participants today. We really thank them. So, welcome.
Well, good afternoon, everybody. I am so excited to be back at the law school this morning to talk about legal research. Is it my understanding, is everybody in the room a third-year law student getting ready to graduate? Is that the case? Is it a mixture of first, second, third years?
I think first years are the largest contingent.
Okay, sounds good. Well, I remember, it wasn't too long ago that I was in your shoes and thinking about what my summer associate program was going to look like, or my internship, or what my summer was going to look like when I studied for the bar in Lexington, which was a long, very quiet summer, and then getting ready for my first job. Just to give you a little bit more information about my background, the perspective I bring today is really threefold. When I first graduated, I had summered at a firm in Louisville, Kentucky, and had found out from that firm about 3 weeks before I was set to take the Virginia bar that they had extended an offer. Graduating with the class of 2010 really wasn't too different than graduating with the classes of 2013 or 14 or 15, in that offers were generally made later in your third year. But by that point, I had met my wife, who's a first-year law student. So rather than go to Louisville, I decided to stay in Lexington and took a job in the Commonwealth Attorney's Office in Lynchburg. Actually drove up and over the mountain each day through Buena Vista to be a prosecutor, which was really exciting. You see a lot, and Chris will tell you too, you see a lot as a prosecutor. I was glad to have a mountain that separated me from maybe some of the defendants I prosecuted. So I spent about 2 years in the Commonwealth Attorney's Office, and so I'm going to talk to you a little bit, just kind of what my perspective was with respect to legal research and working as a new prosecutor there. From there, when Jen graduated, we moved down to Roanoke, and I worked for a very small law firm called Frith & Ellerman. Some of you may know Bo Frith, which is why I asked how many of you were third-year law students. Bo's dad was my boss. So I worked for Dan Frith and Lauren Ellerman for a number of years, and then recently joined Gentry Locke Rakes and Moore this year. So hopefully I'm going to try and give you some tips when we talk about some of the different topics this afternoon, giving you a perspective of working in government, working in a small law firm, and working in a big law firm. And there's a good chance everybody, when you graduate, will probably work in one of those three categories. So I'll try and give you really relevant advice. Look forward to speaking to you this morning.
Thank you, sweetheart. My name is Jennifer Dean, and as you may know, I graduated in 2012 from Washington and Lee. Rob waited the patient for leave paper for me as my graduation date approached, and I accepted a position with a small law firm. We have about 3 attorneys and 10 to 12 support staff now. We focus entirely on immigration, and you'd be surprised at kind of the immigrant communities we do have in Southwest Virginia outside the Roanoke-Salem area. And that's what I focus my practice on. I can really explain to you today about what legal research looks like in a small law firm context, especially since the majority of law firms that are hiring nowadays are going to be your small to mid-sized law firms, and the legal research tasks and your goals in that area probably do differ greatly than kind of the larger firms that Rob is at now. I mean, you have 80 plus, 60 plus attorneys in your office, right, in downtown Roanoke. Whereas with the 3-attorney law firm, we have much more constraints on our legal research. We want to make it as efficient, effective as possible, typically within a short amount of time, because our immigration practice is somewhat high volume practice. So I'll be able to share with you guys on what works for us and some tips on making your legal research as effective as possible.
Well, thank you all for being here and having me. I'm Chris Russell. I'm the Commonwealth's attorney in Buena Vista. And I've been a prosecutor for about 12 years. Before I moved to Buena Vista, I was an assistant. I had a job like Rob, being an assistant prosecutor. I was here in Lexington. And my goal always, I went to Notre Dame Law School and graduated in 1995. And I always wanted to be a courtroom lawyer, standing up, making arguments to a judge or jury, and that's probably the main reason that my job has been, my career choices have been rewarding, because I've gotten to do that. I direct the prosecutor externship program for 3rd years here at the law school, and Rob was in that program this 3rd year. You worked in, was it Lexington?
Rutgers County.
Yeah. Lexington, Rockbridge. And then there's another graduate who's, did you work with Pat in
I did.
Lynchburg? So there's a recent law grad still over in Lynchburg, and several others who prosecute in this part of Virginia. So if you want to practice law in the courtroom, certainly as you approach your 3rd year, think about the external programs or the in-house programs that give you, real life experience. I guess we have some panel discussion questions here in front of us. I don't know if you guys have these questions, but I'll just take a stab at one of them and then turn it back over to the deans. But so I'm just a one-attorney office in Buena Vista, and use a combination of online research and old-fashioned, book research and treatise kind of research. One of the questions that's here in front of us about is, how does legal research at your practice differ from research in the law school environment? And I'll just take a stab at answering that question briefly. I've had interns work for me in the past, and I was an intern at a prosecutor's office myself when I was in law school, and at the Department of Justice also. And I think the biggest answer in terms of government and prosecution work, legal research, is really designed to get us the answer quickly, get us the answer in a brief, concise fashion. Even in sometimes the research I do is because a judge has asked for it. I have a case that has gone to trial or is in the middle of a motion to suppress, and the judge says, well, I don't know the answer. The defense is arguing to throw out this statement the prosecution is saying that it should come in. There's a point here about custody and Miranda, and I'm not sure where the current law is on that in Virginia and in the federal system. So let's adjourn this hearing for a week, and you each side give me a brief. I had a recent case like that, just on the sufficiency of the evidence in the child abuse. And he wanted the defense to submit a brief first, and then the prosecution to respond to it. And the defense lawyer is a more recent law grad than me. And he took the approach of, I'm going to write a brief like you're taught in first-year law school. And he had a heading and subheadings and paragraphs that were double-spaced, and set out the facts that the judge had just heard, and then went through the law and set out some of the facts of the cases that he was citing. And I took a totally different approach that I found effective having practiced for 15 years, which was, not to tell him what he already knew, and wrote my brief in a letter format with fewer subheadings and, single-spaced paragraphs, and, cut right to the chase. And when I wanted to cite a case, I gave them the citation, and then, an indented paragraph with 3 or 4 lines of the quotation that I wanted to rely on. And then, a concluding paragraph why I thought that was what was most applicable to this situation. So, to me, and I'm not the person to speak for what it's like in a big firm in Roanoke or Washington, D.C. And the partners there for a summer associate may well want more of the law school for California. But just to give you the flavor of my experience in a small prosecutor's office, when your supervisor or a judge asks for research and wants the answer, I have found it really helpful to really, unlike law school, just boil it down, find the answer, and give it to who's asking for it in the summary.
Yeah, I have to completely agree. In the immigration context, we are at the intersection of federal, state law, and it's also deportation context for individuals who are facing deportation in the United States. It's actually considered an administrative proceeding, not a criminal one. So they don't have the right to call witnesses. They don't have the right to have an attorney provided for them on behalf of the state. But in that area, I would want to emphasize to you guys how important it is the skills you're learning now. I did not know I wanted to practice immigration law until my 3rd year here at WNL. The legal research skills I was taught in my 1st and 2nd year are instrumental to what I do today. I'm looking at federal statutes on a daily basis, federal case law, how it intersects with state case law, administrative rulings. And so it's really key that you pay attention, especially kind of your blue book. Always keep that with you while after law school you rely on it. And if not, there's also manuals of style in your different contexts. For example, in the immigration court context, I have their own manual style to follow for my citation. So it seems like a lot of grammar and kind of the nuances of citation context, but when you're presenting an argument for the judge, and whether your client's livelihood or their future in the United States or whatever context you find yourself in depends on it, every ounce of expertise you can bring to the table is helpful. At our law firm, because we're small, we have to be a little bit efficient. And in immigration law, it can be difficult because the law changes on a monthly basis. We had one instance where, fortunately, we had the day of our final hearing for a deportation case, and this new ruling was handed down from the Board of Immigration Appeals, which sits right below the 4th Circuit. We take our appeals to the 4th Circuit all the way up to Supreme Court, but at the BIA level, it's still national law. And so this case came down the day of the hearing that overruled a lineage of cases that otherwise would have adversely affected our client. And having known that the day of made all the difference, especially when our opposing counsel may not have done research that morning, and so they were pleasantly unsurprised when we were able to bring those new cases law to light, and which made all the difference in our client's case. So really doing what you can to stay abreast of the changes in the law is very important. I know, depending on what area of practice you're in, sometimes there are listservs which are key. I'm with the ALA listserv, the Federal Bar Association, and they give you daily emails and kind of summarize the case laws either in your circuit at the national level. You can really kind of narrow down what jurisdiction you're interested in, and then they'll send you your daily emails or weekly emails telling you what the changes are that week, and then you decide for yourself whether it applies in one of your cases. Conferences are key. When Rob and I just came from the Virginia Trial Lawyers Conference, it doesn't really apply to my area, but he was speaking, and I was attending some of the CLEs there. Those are very important. As you'll know when you graduate and start practice, that continuing legal education is mandatory. You have to complete so many ethics requirements and credits per year, and so that in and of itself helps you keep abreast of the law. But to really hone in on your practice and provide the best services for your client and for your firm, definitely staying abreast of the changes and making sure you monitor new cases and who's bringing those cases and what their likelihood of chances of success are, what their legal arguments are. Even if it's just a theory that may not have worked in one jurisdiction, it might work in the 4th Circuit, whereas the 9th Circuit would never have a chance, or vice versa. As you probably learned by now, the 9th Circuit diverges entirely for kind of the legal jurisprudence of the rest of the country. So always take lightly what you find in California and in the 9th Circuit over on the West Coast. But at the same time, you can always get a lot of creative ideas if you want to try them out here in a novel context. So that's kind of overview of practice, but they have to go into specifics a little bit later about how you do the research.
I want to go back to something Chris said, which I think is actually a really good point. It sounds like, when you have something in court, in that particular situation, you had a traditional approach, issue, brief answer, long argument or discussion, conclusion. And it sounds like that was probably a pretty lengthy brief, and knowing the judge has a lot on his plate, probably took a lot of time to read. And Chris, based on his 15 years of experience, was able to kind of get to the point and get it right. And what I want to say is when you are either a summer associate this summer, or certainly when you're a new attorney, legal research boils down to actually a value, and that value is credibility. And it doesn't matter whether you're talking about legal research for a judge or legal research for a partner in a law firm, your credibility, meaning your ability to gain the trust of the judge or your ability to gain the trust of either your supervising associate or your partner, is what legal research is all about. And either partners or judges are busy people. So in order to gain their trust, you really have to do two things. You have to get to the point, and you have to get it right. And I'll give you an example. So I was in federal court yesterday morning. We had 7 attorneys there. We had 8 different motions for summary judgment on a variety of issues. We had a judge that had set a 2-hour hearing to hear these 8 motions, which would have been impossible to cover every issue. He also had a lengthy criminal trial at the U.S. Attorney's Office in the afternoon. And one of the defense attorneys from Richmond stood up and started reciting what the standard is under Kelotex for summary judgment under Rule 56. And the judge jumped right in and said, look, let's get to the point. Let's move on here. And just by making that one mistake, by not getting to the point, he had kind of lost a little bit of credibility in court. You have to recognize that the judges or the partners are really busy people, so you want to get to the point. The second part of that value, though, to gain trust of the folks that you're working with, whether it's a judge or a partner, is you have to get it right. And in order to get it right, this is kind of the general process that I follow in my practice. And this is what I've done from day one when I first started practicing, even as a summer associate. You want to start general, and you want to whittle down to something very specific. So how do I start general? If I have something I have to argue in court or with a partner, I get a research assignment, I'll start where most people start when they have a question about literally anything in the world, and that's google.com. The reason I start at Google as opposed to Lexis is because I don't necessarily know what the universe of cases are going to be until I've found maybe a really good secondary source, a blog article or a journal article, or if you're in a firm, you have a document management system, you can find prior art or prior work product. Get a secondary source, find the key cases. And then from there, you whittle down to your jurisdiction, or you whittle down to what the key cases are. You move from Virginia Supreme Court maybe down to the Virginia Circuit Court. So you become more and more specific over time. But that's really what it's about in terms of legal research in a general sense. We're going to talk about more specific practical tips today too. But it's about credibility. You have to get to the point, and you have to get it right. And usually you don't get a second chance to make a first impression. So it's really important to get things right when you represent to the court or to a partner.
A quick note on that, I found that one thing that I struggled with when I was first a summer associate at Bowman & Brook in downtown Richmond, national law firm, is when the senior partner would sit me down for a legal research assignment, I would have my notepad, and they would speak probably a mile a minute, and I would write down 30% of what they said, but I would have questions regarding the scope of my legal research or what they exactly were they asked me for. So what I recommend is that bring your phone and literally record that conversation discreetly, maybe ask permission if you need to, but then you have it. And so if you have any questions, you don't have to go back to them first. They don't think that, you didn't understand what they were assigning to you in the first place. You can review it. And then if you do have questions, always follow up, because that lost time, whether it's an hour or a few hours you spend on a legal research assignment in the completely wrong direction that they otherwise asked for, is lost time, and again, as Rob said, lost credibility.
Yeah.
So just starting up front, getting a clear idea of what the scope of your research is and what their goal for your time is.
That goes back to the first practical tip I want to give about legal research when you're going to be summary at a firm or working in government office or something. How many folks are just getting ready to do an internship or a summer associate this summer? Raise your hand. Okay. How many folks, that's going to be the first time they've done that? Raise your hand. Okay, so a fair amount. Some tips for success this summer. Here's what I recommend. An associate or a partner comes into your office, or a supervisor comes into your office. Just say, hey, I want you to research the interplay between a federal rule of evidence and some substantive law in Virginia. And just please, give me what's the current state of law, or give me a 50-state survey or something on that. And they leave your office because they're busy and they have a bunch of other things to do. And you may wonder, okay, do I dive into the assignment, or what's my next step? Here's what I recommend you do. Before they leave your office, say, do you need it by this afternoon? Do you need it by Friday? When do you need this? Get them to give you a date. If they say, oh, no rush, say, okay, so is next Friday okay? Really get a date before they leave your office. It's so important. Then it's as simple as sending an email after they've left your office, just with a confirmation in writing, and it's a CYA email. I'm going to research this issue, and I'll have my memo to you by next Friday. That way, you and they are on the same page in terms of when you're going to prepare that research product. And so when you under-promise and over-deliver, if it's next Friday, you turn it in next Thursday, they're really happy with your work. They're happy that you met a deadline. And that way there's not a miscommunication, which happens sometimes with summer associates where they were expecting it that afternoon, but if you didn't clarify, that could really be a problem during the summer. So get dates and get something in writing confirming what your assignment is. That's probably the first practice tip I
And
throw
get it
out.
in before the deadline.
And of course, get it in before the deadline and turn in good work product.
I think both Rob and Jennifer have mentioned or hit on this topic, and the Bloomberg guys also mentioned something about this too. There's a good chance that, and people say, don't reinvent the wheel. There's a good chance that some of the research has been done before. Jennifer was talking about going to a conference that maybe wasn't exactly along her practice lines, but it's such a great thing to do. I mean, don't forget the concept of human interaction. I think I probably made this mistake when I was at the Department of Justice in a summer position, thinking that I need to do everything on my own and sort of hole up in the office space I got and try to produce something entirely my own. Now, I don't know what it's like to be in a big private firm as a summer associate. They probably do want to make sure that you can do the work yourself and not rely on others. But in my job now, another thing Jennifer said was, listservs. We have a big network of Virginia prosecutors that has a forum on Yahoo groups, and all day long people are asking each other questions, and people say things like, I'm in the middle of trial right now. We just took a lunch break. I need a case on this. Anyone have one handy? And it's really great to see how many people will directly answer that question in 15 minutes or less. Say I had this come up a month ago, and here's the case. Here's the site. Good luck with your case. Chances are wherever you go, there's going to be someone you can look to that knows something about your topic or has done it before in a general sense or specific sense that can point you in a great direction. So, take advantage when you can of times when you can meet other people, meet other lawyers, other summer associates, and just ask people for advice, and it'll help you get a job to, polish those networking skills as well. There's another question on here about how do you organize your research, and I don't know if this is, you could answer that question different ways, but along those lines, if I've researched an issue, and I do tons of research on criminal procedure, search and seizure, Miranda, confrontation, interrogation, and stuff like that. If I find a case that is helpful to me, on a pending case I have, what I'll do, and I've used Lexis and Westlaw, and the Virginia State Bar has this thing called Fast Case. Do you guys use Fast Case? It's not quite as good or as easy, but it's free to Virginia lawyers. And I use all kinds of different things. And if I find a case that I like, I will save it to my own hard drive. I have folders and subfolders and subfolders, and I'm constantly organizing the files on my hard drive. And I'll save it not just the name of the case, Dean versus the Commonwealth, but I'll create a new name for that case that tells me something about what it said, like Dean versus Commonwealth, drug dog at traffic stop and defendant statement. And when that topic comes up again, and it will come up again, in a year, 18 months, 2 years, It's so much easier for me to find research I've already done when I look in a folder that has 25 cases and it has more than just the name of the parties on it. And even if you save your research that you do this summer, even if you go into a different practice area, save it somewhere on a cloud drive or just on a thumb drive or something, because who knows when it will help you again to have that movie.
I'm so glad that Chris mentioned that, because one of the hardest things for me when I was a new prosecutor was the learning curve. And that's going to be the hardest thing for especially 3Ls who are graduating. When you get into your job, whether you're doing bankruptcy work or commercial litigation, whatever you're doing, that learning curve is very steep. And let me ask, because I see a lot of Mac computers in the room. How many of you all carry an iPad or use an iPad at school? How many? Okay, just a few. When you get into practice, actually, I recommend buying one and having one. Compared to a laptop computer, they're relatively inexpensive. I spent 4.5 days out of the week actually in court. I carry my iPad with me everywhere. And I would use Chris's system, which was whenever I read anything, by the way, I'm allergic to paper, so I would just read PDF copies of things from Lexis or the web, online or whatever. And when I read it, I would highlight it on my iPad. I used an app called Goodreader, which I really strongly recommend to y'all. It's basically a file cabinet on your iPad. And I would connect my Goodreader app to my work computer using cloud-based service. So in the CA's office, we're really comfortable using Dropbox. It's really popular, obviously. There are other options out there. Box.net's really good. Within our firm, we use a proprietary kind of industry-grade cloud-based solution, but it's kind of the same system. But basically what it allows you to do is you can set up the folders like Chris talks about in your Goodreader app and kind of have a mobile law library at your fingertips. And when you read something, you can file away in your folders in the Goodreader app and sync it to your desktop so you have your legal research with you kind of wherever you are, desktop or you're away from the office. And this is why it was helpful. So if I'm standing up in court, and I'm in General District Court, for example, and the judge just throws something out there, with the click of a button, I could usually find that case in my Goodreader library. And I've had that library now since 2010. When I passed the bar, my wife got me an iPad, and I just threw it right into my practice, and I've had it since then. Literally, every case that I've read in the last 4 years is on my iPad. And so when I'm in partner meetings now at Judge Block, if they ask me something about some discovery rule, I'm able to pull up memos and cases I read 3 years ago, kind of dealing with that same topic, rather than having to start from scratch every time. It also really helped me with the learning curve, which I talked about at the very beginning. So I strongly recommend using Chris's system either on your desktop computer, start keeping a folder library of cases, or even better yet, connect that folder library using Dropbox or something and sync it to your Goodreader app on your iPad. Because it's so much easier. I mean, how many times have you written a note to yourself on a yellow legal pad and it finds its way underneath your car seat or whatever? You lose that stuff. But if it's on your iPad, you never lose it. It's electronic. You always have it. You can email it to people. It's got your notes from 3 years ago. It's a really awesome thing to have. So especially for 3Ls, if you're getting ready to graduate, I strongly recommend investing in something like that and using it. And if you Google, I mean, there's a bunch of resources on how to use your iPad in your law practice. Especially in litigation, it's really popular, and it's really important to have.
Yeah, I have to say I use my iPad in practice very often. It does depend on what jurisdiction, which courtrooms it allows you to bring your iPads in. In the federal immigration court context, they do allow them, and it has come in handy on more than one occasion. One thing I want to stress too is because you guys are the benefit of the most current state of law now is whatever practitioner's guides and whatever overviews in your classes you received, and if that PDF, for example, save those and then upload them to your iPad, then you have that as a basis. Yeah, more than once. We knew we were going to practice in Virginia. It might be different if you're going out of state, but Professor Wood, I'm not sure if he still gives the Virginia practice and procedure class here, and that was essential. And there was more than a few times that both Rob and I have gone back to my class notes and the guides he would hand out and email to us and use those in our daily practice. So that's a good place to start building your law library on an iPad or electronic device. Our office, one thing we do to curtail our costs because we're a small firm is we are completely cloud-based. Our case files are in Dropbox. Whenever we receive any mail or documents or filings, we scan them into our client files. And we have an online web-based management system where we have our billings, our contact information. Everything's cloud-based. So To the point where I even have an app for my firm that if I'm in court, I can pull up that case information and really review anything I could do in the office right in the courtroom. So I do, and I build the same law library that Chris talked about. We have a file that I probably go to every day. It's the immigration consequences of criminal convictions. And more often than not, we see our clients with involuntary murder charges or convictions against them, marijuana possession, and we need to know what the state of law is and how that will affect our case. That's something we visit and revisit pretty frequently in our practice. So having that research already saved, and especially in Goodreader, you can highlight it, tab it, bookmark it. So sometimes you're faced with like a law review article that's 20, 30, 40 pages long, but you really just want a few paragraphs that are on point. You can otherwise bookmark them and highlight them, so the next time you need to pull that area of the law into a memo you're writing, to a case you're handling, it's really at your fingertips and very convenient.
There's a question on here about ethical constraints on legal research, and this may be a fairly obvious point, but Virginia, anyone that ends up practicing family law or criminal law in Virginia, we have an intermediate appellate court, the Virginia Court of Appeals, that issues published opinions and unpublished opinions. And it can be kind of frustrating sometimes because I get these weekly case law updates, like Jennifer mentioned, and a lot of times there's this great case and it's on point and it makes exactly the point that I want to make in an upcoming case, and I pull it up and I realize it's an unpublished decision of the Court of Appeals, and there's a rule that says, you know, these should not be cited for precedential value. And I guess along those lines, you know, you may come up with you may find a case that's been sharply criticized later on, or God forbid, overruled. Just, you know, your partner or the judge is probably not going to go back and double check the research you did and shepherdize the case you gave him, or something like that. So, you know, that should be, I guess, rule number one when you're doing a memo or submitting some work. You know, make sure you're citing good law, because it may not immediately come back on you if you cited something that shouldn't be cited for its precedential value, or if you cited something that's been, you know, distinguished to the point of that it's really not good to cite anymore, or something like that. And in the end, you know, as others have said, I think today, and you probably heard, since you've been in law school, maybe before, you know, your credibility sometimes is all you've got, and you don't have a second chance to earn the trust of people that you want to hire you, or judges that you want to listen to you for your client or for the work you're doing.
Building on what Chris said, here are some of the ethical pitfalls you might find yourself in as a summer associate or as a new attorney with respect to legal research. The first is probably pretty obvious, although it still happens. Don't cite from a dissenting opinion and not let the court know it's a dissenting opinion. Believe it or not, there was a judicial panel yesterday at the VTLA convention, and judges said they'll actually see that. So, I mean, obviously, use your good judgment about published, unpublished, dissenting opinions, that kind of thing. But here's one that's actually kind of a little bit more of a gray area ethically, but it's really important otherwise with respect to credibility, and that's this. You may be looking for a particular quote or a particular point that you think stands for the proposition that you're researching, and it's really tempting, especially when you can just copy and paste something into a Word document from Lexis, just to pull that quote maybe out of context and drop it into your brief. But what you really should be doing, even though it takes a little bit of extra time, is you have to read the whole opinion. You just have to sit down and read the whole darn thing. It's tempting just to focus on the one paragraph, but there's actually, I mean, I think it's actually an ethical breach if you take something out of context and then you misrepresent it to the court. It's fraud on the court. So make sure you read things in context. Take the time to read the whole case. That's so important. The transition, there's another question that we have in front of us that I think is important to touch on before we wrap up today. And that question is this: how do you keep up with the developments in your areas of professional interest? So basically, how do you stay current on the law? For your partners, for your professional practice, for your clients, how do you stay current on the law? Let me ask, how many people in the room know what an RSS is or use an RSS feed reader? Okay, so maybe a few people, all right. Well, I would recommend, and you probably use that to what? Follow news or blogs or what? Yep. All those things. Blogs, cool. What I would recommend when you get started in practice is go to feedly.com, F-E-E-D-L-Y. Google Reader used to be a really good RSS reader, but for whatever reason, Google, in their attempt to do no evil, extinguished that. I don't know why. They're consolidating into other products. Mr. Reader is a really good one. There's a bunch of really good RSS readers out there. Basically, an RSS reader is this. You input a bunch of blogs that you want to follow, maybe a bunch of criminal defense blogs, maybe a bunch of alternative energy blogs, maybe commercial litigation, whatever your practice is. And your RSS reader, as you guys probably know, on a daily basis, it's like the dog fetching the newspaper in the morning. It will go out and grab those articles from the blogs and put them in one kind of scrollable format, so like a news feed on Twitter or on Facebook. And that's a way to stay current, because usually, 30 years ago, people wanted to write about something. They were probably sending it to the Washington Lee Law Review. Maybe they were publishing it in the Virginia Lawyers Weekly. Nowadays, people are blogging, and law professors are blogging, and practitioners are blogging, and it's usually practice tips and new cases. Blogs are really how you stay current in your practice. And the way you kind of organize all that information is to have an RSS reader. That's something you can throw on your iPad as well. So for example, in my practice in litigation, I follow probably 50 different litigation blogs on electronic discovery and so forth. That way, if there's a new case that comes out in Virginia or elsewhere, I know about it because somebody's blogged about it. And I can send it to a client or a partner or whoever. But as far as staying current with developments in your areas of professional interest, absolutely set up a Feedly account or an RSS reader account and follow blogs. And if I were still in law school in your shoes right now, am I a second-year student or a third-year student, I'd probably start a blog. You don't have to be a lawyer to blog about the law. It's cheap. All you need is a domain name and a WordPress account. You can set up your own blog and start writing about stuff that you're interested in. It's a way to kind of stand out as far as your job search is concerned as well. It's also a way to kind of educate yourself about what you're really interested in, whether it's immigration law or whatnot. But blogs are kind of where it's at in terms of staying current. That's really important. Not to denigrate the Law Review. The Law Review does incredible work. I know we all plan to read the Law Review once we graduate by the fireplace. But in reality, when we're practitioners, it's really about blogging and staying current that way, in addition to the listservs and other things that Chris.
I have to agree, especially because with the blog posts, you have your practitioners summarize the case for you in a way that's really has a common sense understanding. So kind of like SCOTUSblog.com, they do a summary of Supreme Court cases. You usually find that with practitioners who are blogging on your very specific area of the law. And I recommend that if you're interested, you can even take it one step further and contact that blog author. Usually they're very receptive. If you have a question about their case or want to ask about their post from a different angle, they would probably love to hear from you. And the reason I would know that is because Rob, as he started his own blog, walkingoffice.com, where it's about using technology in the legal context and how you can set up, as you already mentioned, Good Reader on your iPad. So if you are interested, it's no longer
It's sold.
He sold it, but the content's still there if you want to take advantage of it. And I do know that people from all around the state, all around the country, started emailing Rob asking for tips about how to set up a mobile law library, how to effectively use the iPad in the courtroom, and he's very receptive and couldn't be more happier than to oblige people with their questions. So I would imagine that other blog authors, other practitioners who are having those entries about case law would also be equally obliged to help you out along the way. One thing I want to touch on briefly is I like this question where, how do you know if your research is complete? Because that's another thing I had to learn in the very beginning of my legal research, whether as a summer associate or as an attorney, is at what point do you stop? At what point is your work product for your senior attorney for a fellow colleague complete? And I found the best way, and you guys are very fortunate, because I'm sure you've had training on Lexis Advance and Westlaw Next, that when you find a cross-section of resources that are all pointing you toward the same conclusion, at that point I think you're comfortable in knowing that what you're researching is the conclusion you should be reaching. For example, if you're looking up a particular case, legal consequence of a cocaine conviction in Virginia State Criminal Court in Arlington and how that affects immigration court. On the federal level, you're working with the state statute, 18.2 what's the cocaine possession statute?
Chris will know.
250.
250.1 maybe?
That's the first offender.
That's the first offender,
That's
okay.
That's marijuana.
But you're looking up with, you're working with the state statute, you're looking at how that state statute might have been interpreted in the federal case law. You're certainly looking at how it's been interpreted in the courts. There may be blogs on these landmark cases that come down and what their lineage of cases that follow it. You're working with kind of, I like the practitioner's guide. So how would you describe a practitioner's guide? It's not case law, it's not, I'm trying to imagine where it is in Lexis next. It would be, for the immigration context, we have something called Fragerman, and it's a practitioner's guide where if you want to file a motion, if you want to argue this, they give you the literally step-by-step of your legal argument, what the fact would be to support it, and what the law, the statutes, the administrative law you need to rely on. So I recommend kind of finding the practitioner's guides in your area and using that as a good source. But when you're at the point in your legal research where you're seeing a case cross-reference, you're seeing the statute cited repeatedly, you're seeing the same holdings, maybe you see some divergent holdings, but you're really coming towards that consensus that what you're researching is on point. I think that's when you know and you feel comfortable with that your research project is complete and ready to be polished and passed on to your senior attorney.
Yeah, those how-to guides, I guess in Westlaw Next it would be secondary sources or
Right.
something, and they'd have practice manuals and stuff. And they are secondary sources, but a lot of times the footnotes in those are
Right.
really good and can point you right where you're going instead of just throwing yourself into an advanced search. So yeah, that's a good point.
And I just try to stay away from the dollar signs if I run into them, because we have a flat fee system with our Westlaw Next. And so just reining in the costs, especially if some are associated, we've heard the horror stories of someone racking up tens of thousands of dollars in extra Lexis and Westlaw expenses. So just be careful of those dollar signs, or if you're certain that you want that resource, maybe go back to Google and see if it's available elsewhere. I know Rob at time has emailed, there's a law review article that he wanted that he would otherwise have to pay for in Westlaw. He emailed the author directly and got their contact information. They couldn't be more happy to send him a PDF. So there are a lot of different ways to get the resources you're looking for.
There's another question here I want to make sure we touch on in the last few minutes, and that is what research skills or habits distinguish an above average new attorney? And what I would say in response to that is good writing distinguishes an above average new attorney. Unfortunately, after 3 years of law school, you spend a lot of time reading a lot of cases, and usually the cases are written and they have a lot of legal substance to them. They probably don't have a lot of literary substance to them. But you have to keep in mind, especially when you go into a private firm, the person who ultimately is going to be reading your work product is not necessarily your partner. It's probably a business owner or a client. Somebody that actually has to understand what the heck you're talking about. And so one of the ways I would recommend to you, if you're not doing it already, that you start doing once you start practicing, is at some point you have to step away from reading case opinions all the time and guidebooks all the time. Just read good writing. Brian Gardner is a legal writing guy, and definitely read his stuff. He had a book with Justice Scalia, How to Make Your Case. Absolutely read that. That's a really good book to read. Read Mark Harmon's The Curmudgeon's Guide to the Law. That's a really good book on legal writing I'd recommend as well. All of Brian Gardner's stuff is really good. But aside from that, just read, folks are writing really good stuff. Read good short story writers. Read non-legal work. And remember what it means to actually be a good writer and enjoy writing. Many of us in this room probably went to law school because you love to read and write. And it's easy to kind of lose sight of that when you're so busy with law school. But once you get back into practice, start thinking again about what good writing looks like and make your legal work look like good writing rather than your legal work necessarily look like case opinions, which sometimes can be convoluted and difficult for clients to understand. So good writing really will distinguish you. And the way you have good writing is to read good writing. So really do a lot of outside reading once you graduate.
You will get the chance again. I know it doesn't seem like it now when you have 70 pages in a case law book, but
Yeah, you actually get free time again, which is really exciting.
That's it. Good luck to you all. If there's any questions, I guess.
Yeah, we still have 10 minutes on the clock. So I guess while we're all here, if anybody has any questions for Chris or Jennifer or I, now's probably a good time. Otherwise, I know you've had a long morning, and you're probably on your Southern End food coma. Oh, yes, sir.
What's a flat fee subscription look like for a small firm like yours?
I think off the top of my head, if it's a solo practice and it's at Lexus or Westlaw, it was something like $300 or $400 a month. I mean, you can get some really good flat fee, just Virginia or just New York or just Pennsylvania subscription prices. That being said, if let's say I was going into a small firm or I was starting my own solo practice in Virginia, I would do this. I would rely on Google Scholar and Fastcase, which is free, and I wouldn't even mess around with Lexis or Westlaw. Because oftentimes you can get what you need through a lot of free resources, and it's not totally necessary to pay for that up front. That being said, I mean, it's anywhere between a couple $100 a month and a little bit more if you're in a bigger firm and you need more licenses.
Yeah, we're about a couple $100 a month, and I would encourage, if you want to work with kind of the Westlaw and Lexis reps, they're very flexible. They have a lot of authority of what deals and discounts they can give you and what resources you can include. So we just kind of pick our jurisdictions and our practice areas and what access that we want. And then if we actually happen to run over at a particular month because of one research that I had to get this case I couldn't find elsewhere, typically they'll write it off. So just really develop a good relationship if you want to consider the flat fee route with a Lexis or Westlaw rep, and they can be very flexible, and they're encouraged to work with you and have your business over time so that you can work out something that's comfortable financially for you. But at the same time, using Fastcase and other.
I was going to say, I disagree. I think Westlaw and Lexis are artificial monopolies and just really create barriers to entry to people. And there's so many good free resources that are out there now that I would, before you think, all right, I'm going to buy into the Death Star and pay for a subscription, like look for free resources. And Fastcase is one of them. I love Fastcase.
But what free resources can get you, I mean, Fastcase is literally cases and statutes. You won't get the practitioner's guide. You won't get kind of the overviews of the legal areas. If you want something more in-depth, more comprehensive, I think there are certain practitioner's guides only available access or Lexis that you can only get through those subscriptions. Certainly there are alternatives that, with case law statutes, those are easily farmed out. But there are certain areas and certain practitioner's guides and court manuals that you might not be able to access online with the court system. You have to go through Lexis and Lexis.
Right.
That's my rebuttal.
And I'm not saying, let's say you're starting a practice. I'm not telling you that while you have your free student account, you should go on Lexis and start downloading just huge libraries of PDF guides. I know you could do that conceivably. I'm not saying whether you should or not. But I just know that's an option. Know that's something you can do.
Also, along those lines, there's so many advantages to the digital age. I went to college and law school where we didn't use email in the 1990s, but really maybe 5% of people used email. But don't be afraid to buy a book either. You're going to wind up in a practice area. Whatever practice area you wind up in, there's going to be a good book, that covers a lot of practical things, has summaries and updates and new editions, and you're going to, for a good one, you might spend $100 or more. But don't be afraid to buy a book or two just for yourself and use that.
Books still exist. They have paper and stuff. You buy them. They're very helpful. Well, folks, I think that's it for us. I think we're probably out of time. Thank you again for having us this morning. We appreciate it.